Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as your law intellect. I hope you guys are having a fantastic day. We are here to talk about Donald McClurkin. Yes, Pastor Donald McClurkin on late yesterday did file an answer to the complaint. For those of you that don't recall, Donald McClurkin was accused of some essay and assault allegations by one of his former personal assistants. He has come out and vehemently denied each and every allegation, and pretty much that's what he did in the answer. He did not respond with any motions to dismiss it. He responded with an answer of which you will see that he pretty much denied every allegation except for a few. And he provided a slew of affirmative defenses. So it looks like this is a case that is going to go through litigation and will potentially have depositions, various motion dates, and maybe a trial. Who knows? But what I want you all to do is hit the like button on your way in. Hold on one second. Sorry about that. Had to answer the door. But anyway, as I said, it looks like they are going to go through the litigation. Donnie McClurkin has come out a few times and, of course, said, he denied it. He denied, said all this isn't true. He had a statement that it came out. Then he said he wanted you to hear directly from him. So we went over that video as well. So make sure you all go back if you guys have not seen it and catch up. But for now, what we're going to do, because we're unbiased, we're trying to be fair on both sides. So because we talked about the complaint, we will talk about the answer, no matter how manila and general and template it appears to be. Typically, I don't go over answers because, as you'll see in a minute, it's very just general and generic. I mean, they admit, they deny, neither admit or deny, and then they give a slew of affirmative defenses, which some may or may not apply. Thank you so much, Granny the Great, for the super chat. I appreciate you. So let's pull this up real quick. I won't be before you long. I'm going to get back to work because you guys know I was out sick, so I'm trying to catch up on my life right now. All right. So here we are. Let me put myself down here. All right. Here we are right here. This is the answer to the complaint. Defendant Donald McClurkin, by and through his attorneys, and for his answer to the complaint filed by plaintiff, responds as follows. So as you see, defendant denies knowledge or information sufficient to form belief as to the allegations set forth in paragraph 1. So you're going to get a lot of that. You're going to get a bunch of defendants denies the allegation in the next paragraph. And so what is happening right now, for those that don't know, is we went over the complaint. The complaint is structured in various paragraphs. And when you answer the complaint, you admit, deny, or neither admit nor deny because you don't have sufficient information, or because it's saying a legal conclusion, your jurisdictional amount, or certain things that you just can't answer because it's really not anything to answer because it's not really, you know, providing any substantive information. And so he's done that, pretty much denying all of the allegations that are waged against him. The only thing he admits in 4 and 5. That's basically where he lives at. All right. He admits that he is in New York. That's, that's as good as y'all getting. So he also hold on. He also admitted, so paragraph 4 was that all times relevant to that Donald McClurkin was a resident of New York, and he admits that. He also admits it has that all times relevant defendant McClurkin was and is a famous gospel artist and preacher. He admits that too. He says he's a famous gospel artist and preacher as well. So he does admit that. Then you go on, and again, it's a bunch of denials. Bunch of denials. You all see he's given his facts. You see that? 18 through 42. Straight up, defendant denies the allegations in paragraph 18 of the complaint. And it says the same thing all the way down. So those are basically the allegations, the factual allegation portion of what the plaintiff alleged in the complaint. So, I'm not going to go around and just say defendant denies, defendant denies. You see why I don't really go over the answers, because it just doesn't have much to it. But he is in this lawsuit now. He is in the lawsuit. I told you all when he was served. So I was looking to see when the lawsuit was going to actually come forth. He did admit, which one is this? I think it was paragraph. Okay, I got to go through the ones that's not a denial. Paragraph 44. He did admit that, Donald McClurkin, and that allegation said, however, because defendant McClurkin was a gospel artist, plaintiff continued to encounter him through his new employment. So basically, even when this plaintiff left, I guess, Donnie McClurkin's church, he alleges that in 2018, he ultimately secured employment with the Christian Broadcasting Network in New York and successfully resigned from his position with defendant McClurkin. So that was allegation 43. Allegation 44 was, however, because defendant McClurkin was a gospel artist, plaintiff continued to encounter him through his new employment. So Donald McClurkin admits that he did see him in these situations of Donnie McClurkin coming to his place of business because it was a Christian network. So he does admit that. He denies all the text messages, denies all of that, the emails and what I guess they're saying the emails say. Let me see. I tried to highlight what he was actually admitting, but so if you all recall, his causes of action were the violation of the Victims of Gender Motivated Violence Act. That was the first cause of action. The second cause of action was sexual assault. The third cause of action was sexual battery. So those were the causes of action. There was a demand for a jury, and Donnie McClurkin also demands for a jury as well. Let me see, because I know he has some more. He admitted like 2 more things. It wasn't that deep, but Let me see. It was 44. He admitted paragraph 14. Hold on. What did paragraph 14? Yeah, he admitted paragraph 14, which basically said in the complaint, eventually defendant offered plaintiff the position of executive and personal assistant with which plaintiff accepted. So he did admit that this guy was his personal assistant. So he did admit that. I think that's it. Everything else is neither admit nor deny. Yeah, that's it. That's all we got. That's all he admitted. So there's that. Yep, he said he wanted a jury trial. All right, see you back. See you later, sis. Um, yeah, he did say he wants a jury trial. Let's go over his affirmative defenses. Again, they're very general. Probably everybody throws most of these affirmative defenses in there, but it was a couple that made me snicker a little bit. So his first affirmative defense is the complaint fails to state a claim upon relief may be granted. So he's basically saying that he didn't proffer any claims that you can get relief from, is what he's alleging. But I mean, if that was the truth, it appears that he probably would have done a motion to dismiss off rip. But nonetheless, his second affirmative defense, plaintiff's claims are barred in whole or in part by the statute of limitation. Remember, that has been an issue with the gender motivated act. I believe that that is something that has been a split, where you have some justices that do believe that, or some jurists that believe that it is barred, and you get some that believe that it is not. So it's in the Court of Appeals. I don't think they've actually made a decision on that. But Sean Combs has, I believe, gotten some cases dismissed based off of that, or some claims dismissed based on the statute of limitations. So that is also pled. The third affirmative defense is this court is not the proper venue because none of the allegations raised occurred in New York County, and New York County has no relation to the incident raised in the complaint. Again, this is just general, probably until they see where they're making these allegations at when they get into discovery. The fourth affirmative defense is none of the incidents alleged took place in New York City, nor is there any nexus to New York City raised to the extended statute of limitation. Does not apply. The fifth affirmative defense is plaintiff claims are barred by the doctrine of impossibility. Sixth affirmative defense, plaintiff's claims are barred by the doctrine of unclean hands. The seventh affirmative defense, plaintiff's claims are barred in whole or in part by the doctrine of events beyond the control of the defendant, impossibility, impracticability, and or frustration of purpose. Eighth affirmative defense is the complaint is barred in whole or in part by the doctrine of waiver and estoppel. Ninth affirmative defense, plaintiff's claims are barred in whole or in part by the doctrine of unjust enrichment. That's an equitable claim. 10th affirmative defense, if any of the events alleged in the complaint occurred, which defendant vehemently and unequivocally denies, the alleged incidents were welcomed by plaintiff. I thought that was real interesting because really it's just a consent affirmative defense, but it seems like they didn't want to just put that it could have been consent as a defense. They made sure that they put he vehemently denies it, but if it happened, it was welcomed. It's like, okay. All right. Yes. Thank you all for all of the likes. I appreciate it. The 11th affirmative defense If plaintiff suffered any of the damages alleged in the complaint, such damages were suffered solely as a result of his own negligent, recklessness, unlawful, illegal, and/or improper actions, practices, and/or conduct, and its culpable conduct is a bar to any recovery against defendant. The 12th affirmative defense, plaintiff's claims are barred in whole or in part by the doctrine of laches, meaning basically it's stale, happened so long ago. It's almost difficult to litigate something like that because it happened so long ago. You should have brought it already. The 13th affirmative defense, plaintiff's claims are barred in whole or in part by the statute of limitations. You all know what statute of limitation is. 14th defense is, so it's a lot of looks like statute of limitation type defenses. They just phrased it in different ways. 'Plaintiff's claims are barred by novation. Okay. That's like a contract. I don't even know how that would, I don't know. Um, 15th affirmative defense, plaintiff's claims are barred in whole or in part by her failure to mitigate injuries and its failure to mitigate damages. 16th affirmative defense, plaintiff claims damages are too remote or speculative to form the basis for relief. 17th affirmative defense, plaintiff cannot rely on CPLR section 213C because when the statute was amended in 2019, more than 5 years had passed from the incident alleged, and therefore any incidents alleged were already time barred and cannot be revived by the provisions of CPLR section 213C. Again, that sounds like it'll go to that gender motivated act, because that's the only reason why they can bring these old claims. If that is where you can't bring it up under there, then all your claims will go away. 18th affirmative defense is any of the incidents alleged that occurred outside of New York State and New York City cannot be filed in this jurisdiction, nor may they benefit from any extended statute of limitation of this state. So basically, they threw all the defenses against the wall. They're going to see which one sticks. Additional defenses, defendant respectfully requests leave to assert additional defenses and/or amend its defenses include any counterclaims as he deems necessary to his defense during or upon conclusion of its investigation and discovery of plaintiff's claim. And so Donnie McClurkin verified. Donald A. McClurkin Jr. affirms, deposes, and says that he has read the foregoing answer and knows the contents thereof to be true to the best of his current knowledge, except as to the matters therein stated to be alleged upon information and belief. I affirm this 24th day of February of 2026 under the penalties of perjury, under the laws of New York, which may include a fine of imprisonment, that the foregoing is true, and I understand that this document may be filed in an action or proceeding in a court of law. And it is signed Donald A. McClurkin Jr. So there's that. Tracy wants to know, Donald, her only question is that your email? That's what she wants to know, Donald. Pastor. Let me see what he said on that one. He probably just denied it. Let me go find it in the complaint so I can answer your question if he just straight up denied it. Let's see. After the incident, 50 okay, so that would be paragraph 57. Let's see paragraph 57. Pastor McClurkin said, defendant denies the allegation in paragraph 57 of the complaint. 57 of the complaint said, after this incident in Niagara Falls, New York, on June 28, 2013, what incident are we referring to? I'm going to refresh your recollection. In or about June of 2013, defendant McClurkin persuaded plaintiff to rejoin his church in New York. On June 26, 2013, defendant McClurkin then convinced plaintiff to accompany him on a trip to Niagara Falls, New York, where defendant forced himself on plaintiff and sexually assaulted him in defendant's hotel room, ignoring plaintiff's pleas for him to stop. This time, plaintiff was able to push defendant off, having grown more confident in his sexual identity and no longer subscribing to defendant's doctrine of, quote, deliverance. After this incident in Niagara Falls, New York, on June 28, 2013, defendant McClurkin sent plaintiff an email apologizing for sexually assaulting him that evening. So what I read to you all were the complaint from paragraph 54 to 57 before we get to the actual email. I'll read the email again as well. So Donald McClurkin denied 54 to 57. So he denied that entire incident even occurred. Now the email that they are referring to reads as follows. It was June 28th of 2013 at 11:36 a.m. My apology. The first thing I want to do is apologize again to you. I know I apologize for my wrong attitude from Wednesday, but I want to apologize for all of my behavior that has been wrong and put you in a wrong place. I am the actual epitome of a desperate, dirty old man, pawning and groping a young man who is just looking for a friendship and close platonic relationship with someone he once looks for help, guidance, and spirituality. I was trying to go to a realm of sexuality that wasn't right and wasn't right for you or me for that matter. I feel so foul, so stupid. I'm old enough to be your father and want to be something else to you. You don't have that desire for me, and I shouldn't have it for you. I forced myself on you, groping on you. And when I think about it, you never really touched me like that at all. Just wanted to sleep together and hug occasionally. I am really embarrassed at how I am and how I acted. You're far too important to be treated like that from me or anyone. I'm not helping you in any way by doing this, and I'm only making a fool out of myself, being so desperate. I have no one, and I feel it more than ever. But I was horribly wrong trying to force you into something that you were consistently saying no to. I am too old to be like this. I won't be that to you again. You didn't come back for this. My loneliness is mine to deal with. My desire for you is not right in the way that I'm feeling and handling it. I will be a friend to you and pastor if you'll allow me, but I won't be this broken old man so desperate for you that I violate my purpose in your life and become this. I love you and want you to be who you're supposed to be. I will work on me. I hate being lonely and alone, but I have to go through it and not like this. Let's move on from here. See you later, this or next week, Pastor. Okay. That is the email. That. Mm-hmm. Any other questions as we say the benediction? So it looks like they're proceeding with the litigation. So it'll be he said, she said, and who do you believe? I need you all to make sure you hit the like button, subscribe to the channel if you have not done so already. I appreciate all the love and support. If you would like to give a super chat, super sticker, the button's down there. Thank you all so much. Also, consider joining the membership. Yeah, Donnie ain't saying much. I mean, that's just what it is. But I had to respond with what he put his response out here. So Jefferson feels like that's an admission. Well, we don't know about the email, and the email has to be authenticated. He's denying the email. So if you deny the email, he said, she said. So that's why Tracy said, "Is that your email?" He denied that paragraph that says he sent this email was sent. So I'm assuming that's what he's denying it, I guess. And I don't know. Yeah, it says he sent it apologizing for assaulting him, and that was paragraph 57. And if you look at paragraph 57, he said that ain't happened. He denies the allegation in paragraph 57 of the complaint, which would mean he's denying the email and the contents thereof. I said that too about why would he put something like that in writing. So, yeah. We have to see how this goes. We can't trust nothing these days. They're going to have to probably get a forensic person, because these days they can doctor up, they can make text messages, they can make emails, they can do all type of stuff. So guess they're going to wait to try to see if they can authenticate it. Yeah, we need the forensic people in the room. Kurt McGee said, hopefully it's not true. I think that the accused and the victim should be asked to take a lie detector test. Just saying. Lie detector tests are inadmissible, as you know. They can be used, police officers, from a criminal standpoint. They still use lie detector tests. Federal, they still use lie detector tests, but it's like a preliminary issue where, like, a lot of people do believe in lie detector tests. I believe in lie detector tests, but it's been such a split in the scientific world that they've never made it as being something that is um that they can validate or verify as if they're giving the correct results. And so it's inadmissible. So it hasn't been anything that's been considered admissible. Now, there are certain incidents, like the fact I do wrongful convictions. So in post conviction situations, sometimes they will allow them, like when we're trying to write a motion for a new trial because of new evidence, and you get an affidavit, and then you may bolster that affidavit with like a lie detector test, or bolster the credibility of somebody who comes forward, and they may recant, meaning they change their testimony for whatever reason. Maybe the police told them back in the day, if you don't say he did it, then that I'm going to say you did it, and you're going to be sitting in that defense chair. Or however they may have tried to bully them, they come back 15 years later when they realize they helped put somebody in prison, and they want to recant. The courts are a little suspicious of recantations under our case law. So we get lie detector tests that may corroborate that. But for the most part, I think it would be cool for him to do one, just because that may, and I've been and put it out. Listen, I'm telling the truth, guys. I took a lie detector test. But ultimately, from it being admitted in court, that's not going to be admitted. That would be deemed inadmissible 9 times out of 10. Brown Mama said, now, if he had this email back then, why not go to the police and report the criminal act instead of years later for money, would be my main question regarding this matter. That is a fair question. Tracy said, to me, if the email is verified, Donnie is guilty. But if the email is fraudulent, Donnie is cleared. So basically, you saying that we don't know, right, Tracy? We don't know. It's all allegations and accusations. you know. And with that, guys, I've done 30 minutes. I didn't even think I can do that much with this here answer that I've been waiting on. I've been literally checking the docket every day because I thought it was due a week ago. And so I'm like, why haven't they responded yet? Why haven't they responded yet? And now they have finally responded, and it's just with the answer that's kind of a general answer to the complaint. So what I want you all to do is do me a favor and have a great and fantastic rest of your day. I'm going to get back to work. And hey, Simply Divine, good to see you. We out of here though. So you're gonna have to roll that bar back, and don't forget to hit the like button and subscribe to the channel. But I'm gonna talk to you all later, all right? All right.